All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, this great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Pryor versus State of Florida, number 2023-0593. And Justice Francis wasn't able to be here this week, but she is going to be participating in all the cases for the week. Just wanted to say that for the record. Thanks.
Good morning. The any crime test must be discontinued, and the most succinct argument, I think, for that is this. In the vast majority of cases where you have a JOA that should have been granted, it's clear that the error could not have been cured. Cases like this court's Monroe decision in 2016, where you watch the prosecutor on the record ask the elemental question again and again and again and just get insufficient answers. Most of the time, the trial record is clear that the prosecutor is aware of the deficiency and you watch him try and fail to cure it. Or it presents like this case, where basically undisputed facts have given rise to a purely legal question. In those kinds of cases where you can't cure the defect, the result should be fundamental error, no matter what the preservation status. You are going to have these minority of cases that the state is worried about, where they're going to be able to make a colorable claim that they could have cured a defect. And we argue in those situations that's still fundamental error, because it's unfair to assume that missing evidence exists if they were given an opportunity to present it but didn't. But even if you are going to assume that, you should only do so in those minority of cases.
So
and
do
if
you
structure
classify the error as a legal one rather than sufficiency of the evidence?
in this case,
Yes. I mean, you mentioned, you said that the evidence gives rise to a legal conclusion, and so I'm curious if you see the error as a legal one as opposed to a factual one here.
I mean, it's factually insufficient if this court's interpretation of the statute is the same as the second DCA.
What fact would make it? What facts are missing that would get us over the sufficiency hurdle? What else would the state have to prove?
The state would have had to prove that what he was actually convicted of was a statute 94440 violation.
That sounds legal to me, though. It doesn't sound like a factual issue. It sounds like you don't have a factual problem. It sounds like you have an exclusively legal question. I just want to isolate the variable before we address it.
I see it as both.
Okay.
Okay.
Well, I mean, it's factual in the sense that potentially there could have been another conviction. That, I mean, you need three qualifying offenses. And depending on how you interpret the statute, you arguably only had two here.
Right.
I mean, what's interesting about this that's different from the other fundamental error cases in this area is that this particular problem, the resolution of as to this particular prior crime was never going to be something that the jury would be deciding anyway. I mean, if someone had raised a question about whether it was the qualifying offense, that would have had to be decided by the judge as a legal matter, and then it would go forward. It's not like the jury is going to decide, you know, is this juvenile escape, does that satisfy the statute?
Well, now they might be able to.
Excuse me?
Well, now, because of how our law has changed, or may change.
I can't hear you.
Could you pull the microphone a little closer to you? Yeah.
I said now, the way that the law is changing, that might be required to be a jury finding, but I agree with you in this case that it would have been judicial.
Yeah, and by that I don't mean that the evidence wouldn't have to go in front of the jury and they would have to say there's three convictions. What I'm saying is that whether you wouldn't ask the jury, does the language of the VCC statute and its listing of offenses, you know, how does this conviction fit into that? The jury decides, was there a conviction? I understand that.
Well, they would be instructed, I believe, on what would qualify.
Right, and so the particular problem here with this statute was never one that the jury was going to resolve.
The problem with its...
Meaning whether this could satisfy he needed 3, whether this could count as one of the 3 prior convictions, right?
I think that was. I think that's part of the jury instructions, and that was part of they're given the lesser of a convicted felon, so I think it was up to them to decide whether or not he was a VCC or a mere felon.
Right, but if the issue had been preserved, if it had been litigated and raised, the judge would have decided, can this prior conviction qualify as one of the 3? But it's okay. I understand your point. Can you back up though? I think before we do the fundamental error thing, it'd be interesting to hear your position on why, under the definition of a VCC and specifically the escape, and then you have what was at the time of conviction 39.061 saying that escape from the juvenile facility is escape within the intent and meaning of 94440. So why? I'm assuming you think that there was error here. You wouldn't be saying it's fundamental error if you didn't think there was error to begin with. What's your response to the state's argument on the statutory interpretation question?
So I have an argument as to Christopher and then an argument as to the statute. I realize that the statute says that it lists these qualifying offenses, and it basically says we'll take adult convictions and we'll take juvenile convictions. But the actual list is what it is. And it's our position that these offenses are not interchangeable, and escape as defined by 94440 means escape from an adult facility, not escape from a DJJ facility or a juvenile facility.
But how do you deal with the phrase that the Chief Justice referred to that occurs in 39.061, which says that an escape from lawful transportation thereto, and this is a statute about escape from secure detention or residential commitment facilities. Escape from lawful transportation thereto or therefrom constitutes escape with the intent and meaning of Section 944.40. I don't understand how your position can be reconciled with that phrase. Help me understand that.
I think if the legislature wanted to list the juvenile escape statute, they could have, or they could have simply
said... Well, the legislature can do all sorts of things, but they did this.
Right,
they did this.
Which
and
doesn't...
how can you reconcile what they did here with your position?
Because they did not list the statute that he was convicted of. That's how it's reconciled. The legislature could have said escape as defined in any statute or escape as defined in both of these statutes, but they didn't. And as to Christopher himself, the record that proves his conviction, first of all, he was 14 years old at the time, and there's a third-degree felony, not a second-degree felony conviction, which clues you into the fact that this was definitely not a 94440 conviction. And also, the other conviction on the same sheet for the same incident was assault on a DJJ employee. So you know that he was housed and escaped from a DJJ facility and not an adult facility. And it's our position that even though there is a definition link, that those two statutes need to be listed in the VCC qualifying offenses list to both qualify, and that only one of them qualifies.
How do you think 39.061 operates in the absence of 94440?
I think basically it just came after it. So instead of...
Does it function correctly without reference to 944 though? I mean, aren't they kind of inextricably linked?
Well, they are, but only because we already had an escape statute, so why not just adopt the language? If the only difference is adult versus...
So, I mean, is your argument essentially that the legislature could have just amended 944, they chose to do something differently though? And I'm not understanding the argument as to why we still can't consider what the legislature did in 39.061 in interpreting whether or not it's a qualifying offense.
You can. It's just our position that unless you list both of those statutes, because they're not the same crime, that they're not interchangeable.
What significance do you place on the different level of conviction, third-degree felony versus second-degree felony?
So 39061 is a third-degree felony and 94440 is a second. So it's just a distinguishing point on the sheet.
And do you think that supports your theory that they are, in fact, two different types of crimes. They just have similar definitions.
I do. I think the legislature could have been perfectly reasonable in their intent to only list certain levels of offenses or to exclude this one for any particular reason.
Do you concede that the DJJ facility is a penal institution? 94440 discusses any prisoner confined in any prison, jail, contractor-operated correctional facility, road camp, or penal or other penal institution, whether operated by a state, a county, or a municipality, or operated under a contract with any of those. It would seem to me that if a DJJ facility is any other penal institution, you're toast.
I mean, having never researched that, I don't know whether it's a penal institution. It's a detention facility.
I mean, detention, I mean, it would seem to me that if someone is detained on charges, that would seem like a penal institution, wouldn't it? It's not an immigration detention facility.
Right.
And then on the conflict issue, do you acknowledge that the decision under review is right under our court's precedent? If we're just looking at I know you want us to sort of take a completely a different approach, but if we're just looking at this court's current case law and fundamental error in this area, the decision under review properly applied our precedent in the sense that if there is a lesser included offense that the evidence showed occurred, that essentially that the fundamental error, that the preservation rule applies.
I think the reason for the conflict is that different courts are applying the test in different ways. I agree that some of the case law does support how the DCA dealt with it, but I think the reason clarification is needed is because they're not all doing the exact same thing.
But we could clarify our precedent by saying it's only when there's a lesser included offense proven, and your client would still lose. The law might be more clear afterward, but you would still lose. The only quote unquote clarification, what really wouldn't be a clarification, it would be receding from our precedent to adopt your position that any time that one of the elements of the offense of conviction, there isn't evidence, that sufficient to prove that can be reviewed for fundamental error. Or that it is fundamental error.
That's what I want, yes.
Okay. So you're asking us to recede from our precedent, not just clarify, but recede.
Absolutely. Our position, to be clear, in the briefs and today, is that the any crime test has no purpose, does not make any sense, and keeps people in prison for longer than is necessary, when a lot of the time, like I was saying in opening, you're going to have the same record on direct appeal that you have in post-conviction. It's going to be obvious on direct appeal that you have a elemental problem that could not have been fixed, and the same is going to be true 5 or 6 years later in post-conviction, and there's simply no reason to cause that kind of delay. I'll reserve the rest of my time.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Jonathan Tannen, appearing for the Attorney General's Office, representing the state of Florida. The state is asking this court to approve the decision of the Second District Court of Appeal affirming Mr. Pryor's conviction for possession of a firearm as a violent career criminal. The second correctly determines that Mr. Pryor had failed to preserve his challenge to the sufficiency of the evidence in the trial court, and that he was unable to establish fundamental error because, at a minimum, the evidence showed that he was guilty of the lesser included offense of possession of a firearm as a convicted felon. This court has held that in the context of unpreserved challenges to the sufficiency of the evidence, fundamental error occurs only when the evidence is insufficient to show that a crime has been committed at all. And the court also stated in FB that the insufficiency of the evidence to prove one element of a crime does not constitute fundamental error. And this court has held on 3 occasions in FB, Young, and Monroe that when the defendant was guilty of a lesser included offense at a minimum, the defendant failed to establish fundamental error. This case in the second DCA presented a straightforward application of that test. Mr. Pryor argued that one of his 3 convictions supporting his VCC status was not a qualifying conviction under the VCC statute. The second first of all, the second agreed with Mr. Pryor, which the state believes was incorrect. But even if Mr. Pryor were correct, he still has 3 prior felony convictions that were proved in the trial court. The evidence at trial showed that he possessed a firearm during the criminal episode that formed the basis for all of the charges. And because he was guilty at a minimum of a lesser included offense, there was no fundamental error, and under Steiger, his remedy is to file a petition for ineffective assistance of counsel under Rule 3850.
And he has something like 15 or 16.
He has a very...
Would none of the other ones have qualified?
I don't know if any of them would qualify under the statute. The prosecutor did not argue that they did. The state submitted 3 prior convictions that were not challenged as far as their qualification under the VCC statute.
Could that potentially be relevant if there were an ineffective assistance claim? If there was another one that would have counted, does that mean there's no prejudice?
It would be, Your Honor. If his trial counsel, let's assume that he files a motion for post-conviction relief under 3850, an evidentiary hearing happens, his attorney might testify that, well, he had these other offenses that all would have qualified. So even if I had challenged that one, there wouldn't have been any difference in the outcome. And under those circumstances, arguably it wouldn't be deficient performance to begin with, but it certainly wouldn't meet the prejudice prong of Strickland. Mr. Pryor's argument with respect to the conflict issue is not that the second DCA was wrong under this court's precedent. This court's precedent is very clear that if a lesser included offense is proven, the standard for fundamental error is not met. Mr. Pryor instead argues that this court should interpret any deficiency in the evidence as fundamental error if raised for the first time on appeal, and therefore eliminate the preservation requirement for motions for judgment of acquittal. Even if this court believed that that was a positive outcome as a matter of policy, that result is foreclosed by the language of Section 924.051, which states that a judgment or sentence may be reversed on appeal only when prejudicial error occurred and was properly preserved in the trial court, or if not properly preserved, would constitute fundamental error. The legislature left it to this court to define fundamental error, but at a minimum, the language would have no meaning if fundamental error were not a higher burden for the defendant than ordinary preserved error. So that argument that the court should effectively abolish the preservation requirement is not available under the statute.
But what do you mean? I don't understand that. I mean, it assumes that there's a category of fundamental error, which sort of by definition means that the preservation rule yields.
Right? That's correct, Your Honor. But if a preserved error and a fundamental error are the same thing in this particular context, and there's no need to preserve the error, then the fundamental error requirement has absolutely no meaning. The court would be...
Isn't the argument just that it is fundamental error, not that, preservation isn't necessary in context, criminal context according to the statute, but that in this case it's always fundamental error?
That's their argument, Your Honor. But if a particular kind of error is always fundamental error, then there's no purpose in the preservation requirements. And the statute further states that all terms and conditions of direct appeal and collateral review must be strictly enforced, including the application of procedural bars to ensure that all claims of error are raised and resolved at the first opportunity. If there is no need to preserve a motion for judgment of acquittal in the trial court, then there is no basis or necessity for the defendant to raise the issue so that it's resolved by the trial court if there's an error that needs to be resolved at the first opportunity.
Can you address on the qualifying offense counsel's argument that due to the difference in degree of the offenses in the varying statutes that it would not be a qualifying offense?
Yes, Your Honor. So the difference of degree makes a difference if the defendant is actually being convicted of the offense. If the defendant escapes from a juvenile facility and is convicted under Section 39.061, then the offense is a third-degree felony, and if the defendant escapes from an adult facility under 944.40 and is convicted under that statute, then the offense is a second-degree felony. So the relevance of the statute and the level of punishment is correspondingly increased depending on the level of the offense. But that's a separate question from whether a conviction under 39.061 qualifies as a qualifying offense for purposes of the VCC statute. And in that regard, the juvenile statute 39.061 states that the offense under that statute, or the conduct prescribed under that statute, constitutes escape within the intent and meaning of section 944.40. So while a conviction under one statute or the other may be a lesser offense, for collateral purposes, a conviction under 39.061 is escape within the intent and meaning of section 944.40, and therefore qualified as an underlying offense here. There was a discussion during Mr. Pryor's argument regarding whether this was a factual issue or a legal one. To some extent, the distinction is blurred in this case because the judgment that was submitted into evidence at Mr. Pryor's trial lists both statute numbers. The jury was asked to make a finding as to whether Mr. Pryor was previously convicted of escape as described in section 944.40, following the language of the VCC statute, and the state submitted into evidence a judgment that said he was convicted of escape, and it listed one of the relevant statute numbers as 944.40. Now, it had a slash and then also listed the juvenile escape number, but Mr. Pryor did not argue in the lower court that the fact that the juvenile escape number was also listed rendered it a not qualifying offense.
Well, that's because the state didn't question. I mean, you guys missed this issue below, right?
That's true, Your Honor. That's true, Your Honor. But he also didn't raise it in the trial courts. He raised it for the first time in the second DCA, and so it was unpreserved. If he had raised it, this would have been an issue that could have been resolved by the trial courts. But the state submits that under the language of the juvenile statute, any confusion about why both statute numbers are on there is resolved. A conviction under that subsection constitutes escape within the intent and meaning of section 944.40, and therefore it was a qualifying offense.
And really, I mean, the bottom line is, even if we thought that there was a need for clarification on the conflict issue, it seems like the proper case to really address that would be one where there wasn't a lesser included offense proven. I mean, we would sort of have to go out of our way. We have precedent from the court that's clear that applies to this case if there was error.
That's correct, Your Honor.
We would have to sort of say, well, notwithstanding that this doesn't involve this fact pattern, we're just going to reach out and say that if this had been one of these other cases where it's, you get convicted of assault and then there's some other completely, different crime, that we would say that the assault sort of takes care of the other one. We would have to sort of go out of our way to address that scenario.
That's correct, Your Honor. The appellant's issue really seems to be more with HR and Bybee, which are decisions from the second and third DCA involving cases where there was no lesser included offense. That may be a circumstance that does need clarification in the future, but that circumstance isn't presented here. In this case, we have a very clear record that shows that at a minimum, Mr. Pryor was guilty of a lesser included offense. And so based on that record, the second DCA correctly determines that there was no fundamental error. And any other circumstances outside the context of a lesser included offense are not presented here. If the court has no further questions, I will rely on the state's answer brief for any further points.
Thank you,
Your
much.
Honors.
We are asking you to do away with the any crime test, and it's our position that this is a perfectly good opportunity for you to do so. The mechanics of sufficiency review don't change based on preservation. It's reviewed de novo regardless. The only thing that changes is the relief. Also, as long as 3380C exists, Florida already allows deficiency to be pointed out beyond the point that it can be fixed. And this is simply the right thing to do. Turning a blind eye on direct appeal to insufficiency of the evidence and making people go through prison time to even start to commence post-conviction, let alone see any relief from it, is wrong. You are not guaranteed counsel in post-conviction. It is permitted by the statute, and it is typically given if you get an evidentiary hearing. But based on how the trial court views this kind of claim, you might not get one at all. When the error, which it is here, is a wrongful conviction, you need to deal with it when people have the most reliable access to counsel, and that is direct appeal, not post-conviction. Does the court have any more questions? I'd like to finish the thought that I started in the beginning. What typically results from, or how insufficiency typically presents, is that it's obvious that it can't be cured. That should govern what the rule is, not the other way around. Not the could cure cases, because those happen a minority of the time. And essentially, if you keep the any crime test, you're letting the tail wag the dog. You are letting something that happens almost never govern what the rule is for everyone. And you are in an effort to shield the state from a potential harm, causing actual harm to human beings who are sitting in prison despite their crimes not being fully proven.
I understand, preservation rules obviously always create this dilemma of allowing errors to go uncured. But let me ask you, it seems like the force of what you're saying would maybe lead one to more of a case-by-case approach, because fundamental error, really all it means is that it's a serious error where you the court, as a matter of discretion, decides not to apply the preservation rule. That's all that fundamental error is. And so it seems like right now these things are set up where the court wants to sort of set these categories and kind of take care of it on the front end. If what you're saying, if someone were persuaded by that, the answer could be to just sort of look at each situation at the appellate level and decide, well, could this have been cured, could it not have been cured, whatever, and then maybe to the extent that it potentially could have been cured, the one where the cases where, was the purse worth more than $100 or less or whatever, you're going to treat that differently than something like this, where if your client had only had 3 felony convictions, and I think this is wrong in this case, but if you stipulate that one of the 3 legally doesn't qualify, then that seems like a different kind of issue.
So our position is that the definition of fundamental error that is most cited and most difficult for defendants to prevail on is that but for definition, that but for the error, the conviction would not have been obtained. And our position is not that you should undo Steiger or let people do IAC on direct appeal anymore or anything like that, but just that insufficiency is different. And insufficiency fits that definition like a glove. If you have a JOA that should have been granted, and the attorney, all he had to do was say something, and the jury would not have gotten the case, the conviction that they returned could not have been obtained. So our argument is that fundamental error exists when you have someone in prison for a greater crime than the one that was proven. And if you refuse to admit that, that is an abdication of this court's duty to serve justice. Thank you.
Thank you. Ready? Okay, our next case is Oquendo versus State of Florida, number 2023-0807.
I'm going to focus on the conflict issue today, unless the court has questions about issue 2, as I believe it to be a clear constitutional violation. So, the conflict issue. You have to understand how PTSD impacts the mind and the body to really appreciate that it could be relevant in some self-defense cases. PTSD can impact your state of mind or fear without automatically resulting in unreasonable violence. But to the extent that this court thinks the second you mention a mental health issue that you're backdooring in diminished capacity to explain a thought process, and only physical maladies matter in self-defense cases, PTSD can get pretty physical. It impairs your central nervous system and can cause physical vulnerabilities that would make a fight for your life or a stressful situation would make those physical vulnerabilities present. And PTSD also can negatively impact your demeanor and your memory, which can result in credibility discounts, which can seriously frustrate your chances of acquittal. The bottom line is PTSD is a complex injury with diverse symptomology, and that diversity makes it way more appropriate for a case-by-case admissibility determination.
Can you address this particular case?
Yeah.
Because it's not obvious how, I mean, obviously there's the issue of just is it relevant per se, kind of relevant or not relevant, but then there's the, possibility of confusion and is it relevant in the particular case. Just looking at this case in particular and, the state's version of events and the defendant's version of events, it's hard to see how his kind of subjective fear, even if you can see that could, that's part of it. There's the objective component and the was he actually afraid subjective component. It's not obvious kind of what this issue has to do with this case.
Do you mean that it was not a self-defense case?
Well, factually, I mean, it just seems like if it, the way that, the two versions of events, it just doesn't seem like in this particular case that really is kind of, it doesn't really have anything to do with what was going on. I mean, the state's version was that the defendant just kind of was, there was no altercation or whatever. The defendant just kind of stood outside the car and, was shooting. Right. And then the defendant's version was that, they were kind of tussling for the gun inside the car. And so it just doesn't seem like doesn't seem like the PTSD issue really fits factually what your defendant was claiming anyway.
Okay. So there are a few examples in the brief that I do think apply to Mr. Oquendo. One of them was that he fled the scene. The prosecutor, of course, like they always do, told the jury that, the second you flee the scene, that's guilty conscience. There's no other reason to do that. He was trying not to get caught. PTSD could provide an alternative reality to that situation that, and this is part of what Dr. Toomer testified to at the proffer, that one thing that PTSD does that's a hallmark of the disease is that once the danger has dissipated, your fear remains elevated. So that could explain his flight from the scene. Also in the DCA briefs, I believe Ms. Shea gave the example of basically overdoing it with the shooting. I think PTSD could explain that in the same way. The danger has dissipated. You've shot someone already. You don't need to keep doing it, but your fear.
I think maybe my question is a restatement of the Chief's, which is I feel like the state could have stipulated to everything you're saying.
Okay.
It still does not amount to what a reasonably cautious and prudent person under the same circumstances would have found to be a credible threat. And that's the test. It's an objective test. It's not, I hear you on the scholarship regarding the disease and the impact it might have had on Mr. Oquendo's subjective understanding of reality. Mm-hmm. Trouble is, that's not the law. That's not what we require in establishing self-defense. It's an objective standard.
Well, just because the court does not see the relevance does not mean that a juror would not have. And
but the court has to instruct the jury on the law.
I understand. So what I would say is you have to be careful, even though the objective standard is ultimately what the actions and thoughts and whatever you're submitting to the jury is judged by, there is a subjective piece, and we have to be careful to not let the objective piece completely override the defendant's entitlement to present his subjective state of mind. And we believe that PTSD in some cases could be relevant to that without resulting in an objective mistake or objectively unreasonable violence.
Where do you think this subjective right, the right to present that, is within what the law allows in a self-defense instruction?
I believe the word circumstances, the defendant's circumstances, so that phrase.
Yeah, but it's a reasonably cautious and prudent person under the same circumstances. So
Of the defendant.
Right, but it would have to be that the circumstances could then defeat the preceding words, a reasonably cautious and prudent person under the same circumstances.
What do you mean defeat?
Well, you're saying that the circumstances could include the person not being reasonably cautious and prudent.
No, I'm not. I'm saying that PTSD does not necessarily make you unreasonably uncautious, or it doesn't necessarily make you overreact. It is a complex disease that can have many impacts on you, and the state wants to characterize it, and the second DCA wants to characterize it as this disease that basically makes you overreact and make mistakes, and it's more than that, and it can have more impacts on you than that. For example, if you take even the most uncharitable or stereotypical worldview of someone that has PTSD, that there's danger lurking around every corner, that everyone's going to hurt me, how that could impact a person could make them overreact. It could also impact them by making them highly avoidant. So like that elder case we cite in the brief, if the way that your PTSD impacts you, according to a clinician, is that it makes you avoid violence, it makes you avoid people in general, that could be relevant to whether or not you're the initial aggressor or not. That could be relevant as to your state of mind. Your state of mind is not just the moment of the violence. In a self-defense case, everything matters. What you did before the violence matters, what you do after, and PTSD can impact many of those things. One other thing that's come up in my self-defense cases in Polk is why the defendant is armed in the first place. That's become a point of contention. The prosecutor will argue this is premeditation, this guy was just looking for a fight. PTSD could provide a perfectly reasonable alternative for that, that's you left the house with the weapon that morning because that's what makes you feel safe. And that doesn't mean that it made your PTSD made you do anything.
Right, but that's
it just means that it's relevant to your state of mind.
Issue, though. I mean, that seems like that's just a completely. You're saying you're giving a hypo of, well, if the question is, well, why would he have had a gun? I mean, in this case, your defendant denied having a gun. I mean, so we're not. I don't think that anybody's asking the court to say that PTSD is never relevant to anything.
I think that's exactly what the state's saying. They're saying that it's diminished capacity.
They're saying that on the specific issue of does it for the self-defense test and the part of it that has to do with the reasonable, what would a reasonably prudent person do under the circumstances? They're just focusing on that part.
I think they're arguing that the second that you let this into a self-defense case that you're backdooring in diminished capacity, and our position is that that's not true. That diminished capacity is different, that it means you are essentially unable or don't have the faculty at that particular moment to have a specific thought, and PTSD works differently than that.
Functionally, legally, though, I'm struggling to see the difference. If your argument is essentially that this is reasonable because of somebody's condition, whether it's diminished capacity or PTSD, but that in determining what's reasonably objective, we look at the capacity of the individual or the conditions that individual has rather than an objective test of the circumstances and what a reasonable person would do, I mean, then it becomes individualized and necessarily focuses on the capacity of the person. So how is that significantly different from a legal perspective?
I'm not sure I heard a difference.
Sorry?
I'm not sure I heard a difference.
Okay, that's what I was asking.
One thing I want to point out is there are many safeguards in our system. I have had many people for many different reasons evaluated over the years at the Public Defender's Office. I have had one client who has been diagnosed with PTSD. That dovetails with the statistics that we cite in the brief, that only 7% of people will ever experience PTSD. And I think that's somewhat of a safeguard. Another safeguard is that we have jury instructions that will lessen the chance that a juror is going to be confused by this evidence or use it in an inappropriate manner. We have 3.6p, we have the standard instructions about not deciding the case on sympathy. We have what you could fashion around a Williams rule instruction, an instruction to use this for this purpose but not this other purpose. And then after all that, the jury is just simply free to reject it.
Can I ask this sort of larger policy discussion? Why is this case, am I right that this was not part of the argument below? All of the sort of data that you're putting in front of us?
You're right.
Okay.
Yeah.
Why would this case be the right vehicle, even if we agreed with you? This is unpreserved. Why would we reach this in this case?
Well, simply because I believe the 3rd district now is following Oquendo. I mean, you have confusion now among the districts, so now is, I think, the time to straighten this out.
So we should just disregard our preservation law to reach this policy question. That's your argument?
Well, I don't think you have to. So as far as preservation goes, we talked about harm, I think, a few minutes ago, but as far as preservation goes, at the time that this proffer happened and this trial happened, Mizell was binding on the trial court. So it's our position that all the attorney had to do was simply say, establish the diagnosis, say this is going to be a self-defense case. He actually testified at trial that this was self-defense. I was in fear for my life. And then at the proffer hearing, the attorney also said, I'm not going to use it for diminished capacity. I'm not going to use it to argue that his actions were involuntary. So he went through all of the sort of safeguards that Mizell has, and it's our position that that is all that was required at the time. Now we're having these sort of larger discussions because there's statewide implications at issue in public policy, but at the time, our position is that is sufficient for preservation. And then you look to whether or not there's harm. But as far as reaching the issue, that's how you get there. I'll reserve the rest of my time.
Thank you.
Good morning. May it please the court. My name is Lori Benoit-Knox, and I represent the state of Florida, the respondent in this matter. For all these other arguments to be preserved, they would have had to be raised in the trial court and in the second DCA, and that's just not what was done here. The conflict issue between the first DCA and the second DCA is strictly whether evidence of PTSD can be admitted to explain the defendant's elevated perception of danger in a self-defense case. There was never any discussion of PTSD used in other contexts or any discussion of physical manifestation of PTSD. That's just not in Mizell, and that's just not in Oquendo.
Do we need to, so if just the standard jury instruction, it seems like it's mainly focused on the objective part, but then there's that last sentence that says that the defendant has to actually have been in fear. So in a case where that part of it is contested, where maybe everybody agrees that sort of the circumstances to a reasonable person would have satisfied the first part of the test, but then for some reason there's a dispute that where the state says, well, but this particular person, notwithstanding what was going on, just factually just wasn't in fear. Couldn't PTSD be relevant at that point? I mean, do we need to be careful if we agree with you to make it clear that really all you're asking about is sort of the first component of the test and not just kind of in general with self-defense?
So the state's position is still that regardless, PTSD would not come in under this actual perception because the actual perception still needs to be reasonable.
Well, that doesn't follow from certainly doesn't follow from like the words of the instruction or the logic of the instruction.
Well, respectfully, I do believe it does, because the actual belief still needs to be reasonable. It needs to be an actual belief that the reasonable person would have had.
But in this analysis here, that's already established. I mean, I think the chief is saying if we say that a reasonable person would believe that there was the threat.
Oh, yes.
But for some reason the state says, well, a reasonable person would, but this person is, for whatever reason, didn't actually feel that. I think that's
that's what I'm saying.
I'm sorry.
That's the question.
I mean, do you have the instruction in front of you?
Which ones?
Those jury, the 36F or whatever it is that we're arguing about.
I believe I do.
It says, the danger need not have been actual, however, to justify the use of deadly force. The appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided through the use of force. New sentence. Based upon appearances, defendant must have actually believed that the danger was real.
Right. So the actual belief that's the subjective part.
Correct.
And so PTSD could be relevant to that, it seems to me.
I'm not sure I understand how that would come out.
Imagine a circumstance where the defendant was actually ignorant of the danger. Imagine that a reasonable person would be really scared if they knew that the person who was holding this orange toy-looking gun was actually holding a 3D printed gun. But the defendant was ignorant of that fact and took action. Now, a reasonably cautious person would be, perceptive of that, but the defendant just was ignorant of it. I guess the Chief and Justice Kennedy are asking, what's the state's position then when there is no provable individual awareness of the danger, but a reasonable person would be afraid? What's the state's position on that?
There's no... A reasonable person would be afraid, but the defendant in this case wasn't. Would PTSD be admissible at that point?
Yes, that's the question. I can try to answer it for you if you want, but I won't.
No, you just kind of stumped me on that one with all the hypotheticals that I've thought about this one.
It seems like there's two parts to this always, right? One is, was the person afraid?
Correct.
Factually. PTSD, it seems to me, could be relevant to that. Then the question is, if I was afraid, then you ask, well, would a reasonable person in these circumstances have been afraid? And that is obviously objective, but it seems to me like there's always an element of this that has to do with the individuals. In this case, I don't think that it matters because that doesn't seem like that's really what the argument was about.
Right.
In terms of like factually what was put in front of the jury, but I'm just saying it just seems my concern is just saying something that's kind of it makes me nervous just in general with evidence stuff for us to just kind of pronounce that something just isn't relevant. If the question is, is this an objective test or whatever, that's different. But you know what I'm saying? I don't want to I don't want the court to overstate what really the rule should be, and I'm trying to ask
But from the
help
defendant's
with that.
perspective, once he claims self-defense, I think in and of itself he is saying he was actually in fear. So I don't know that the defendant, I don't know in that case, in the case that we're coming up with here, it seems almost like we're saying the state would use PTSD against the defendant. I don't really see how.
Well, I have a question that maybe could help rather than that hypo. What about if you had a situation where a reasonable person would be in fear, let's say a spouse situation. And so a reasonable person would look at the series of events and say that spouse should have been in fear. Like objectively, that is a situation. But for whatever reason, the state decides to argue in that moment, hey, this person has been abused like this for years. She knows he'll never go through with it. She had no real personal fear. She's been in the situation 10 times before. Nothing had ever happened. At that point, I think we would say battered spouse syndrome could come in a situation like that. Is that a situation where sort of the subjective relevance of other situations could go to that person's state of mind to say, no, they were actually in fear at that point, once you've established objectively that is a dangerous situation?
So I think the only way the state could argue that battered spouse syndrome would probably come in at that point, because the argument from the state would be that she wasn't afraid, and it would kind of follow proof is she stayed there. And the point of battered spouse syndrome is to say she stayed, and that's reasonable, because when women or men suffer from battered spouse syndrome, leaving is just as scary as staying. And that's what battered spouse syndrome is offered to explain. It's not offered to explain an unreasonable perception of reality.
Right. And so I think what the chief is saying is could there be times where, not battered spouse syndrome, but other situations where a person's sort of mental, whether it's PTSD or some other situation, could that be used to explain that subjective, was that person really in fear? Or is the state saying that these type of things are never appropriate for self-defense instructions at all?
The state's position, based on the second DCA's opinion, is that PTSD does not come in to explain an unreasonable perception, a perception of danger that is only reasonable to the defendant because he suffers from PTSD, that is not reasonable to the caution to the reasonable person.
And so that wouldn't preclude in your argument evidence admitted of, because I think the defense points out that beyond battered spouse, there can be relationships where the history of the individuals would cause somebody to be in fear reasonably. And so from a PTSD, your argument does not preclude evidence in those sorts of fact-specific situations based
Correct.
on the long-term relationships of the individuals.
Correct. So in the circumstances that do come in front of the jury are prior threats, prior acts of violence between the parties. So all of that is already in front of the jury as part of the circumstances. So adding PTSD to that does not serve any purpose other than to then try to explain an unreasonable fear, which by law, once we can put in front of the jury that there's prior acts of violence, I think that makes the circumstances more reasonable.
I mean, what if there's a physical altercation and the person who's saying there was self-defense was like a Navy SEAL, not someone like me, just somebody, and you can imagine the state saying, this guy wasn't afraid. Why, who cares what Carlos would have been afraid of?
Right.
This individual wasn't afraid. And then the defense says, well, actually, I may look tough and I've had all these experiences, but I actually have PTSD. I was afraid. Why wouldn't that be relevant?
So the physical aspect of the differences between the parties would come in as part of the circumstances that the jury can take into consideration as part of the instructions. So if I understand the question correctly, PTSD then would kind of negate what seems obvious otherwise in terms of the reasonableness of the distortion.
Well, no, not because remember,
Right.
the last sentence of the instruction is not about whether it was reasonable, it's whether you were actually afraid.
Right.
And it just seems to me like that could be relevant to that. I mean, in this case, that's not what they were arguing about. So,
Right.
but we're being asked to kind of make this grand pronouncement about it, and I just want to make sure that we don't overstate it.
So I think, though, squarely under the facts of this case, you can adopt the second DCA opinion, because the second DCA opinion is really simply talking about how this is diminished capacity because we're saying my mental illness, my PTSD prevented me from having the same outlook on things as the reasonable person. So I don't think you have a problem here. Now, I hear you when PTSD can come in to negate what, like this physical, the Navy SEAL that says, by my appearance, I look like I should not be afraid, but I am afraid because I have PTSD. I'm a little stumped, to be honest. I'm not quite sure in those situations.
Essentially, we'd have to limit the holding to what the second DCA did. That it's offered for why Oquendo might have mistaken a dangerous situation.
Right. I think if you...
Undangerous situation for a dangerous situation.
Right.
Other than the second half of the jury instruction.
Right. So I do think that if you stick by the second DCA, it is evidence of diminished capacity that should not be allowed, and that it wouldn't come in for the purpose of explaining the misperception. Now, can it come in different circumstances to prove different things? I think that remains to be litigated. But
it seems to me almost like there are two elements, if you will, to put this in reverse. Instead of it being, a crime with elements, imagine that this defense has two elements, and one is objective and one is subjective. Mm-hmm. It seems to me like what the state is really arguing is that on that second element, the subjective one, you would never be making this claim in the first place. You would never be invoking self-defense as a defense unless you were in fact afraid. If you didn't have that element, you could not proceed with this defense.
Correct.
Am I articulating the state's position, or am I articulating Justice Coriel's position?
No, Your Honor, the state's position is in agreement with Justice Coriel.
Okay.
No, that's when somebody claims self-defense, they are claiming they're in actual fear.
Okay.
And obviously the state could contest that in a particular case.
The jury still has to make that finding.
You could say, no, you weren't afraid. It could be because they could invoke things about the person's background, and you could imagine like it's not, you don't have to be he's good at thinking hypos, I'm not. You don't have to be super creative to think of a situation.
I think the Navy SEAL was a good one.
What if somebody said they weren't afraid? Even though a reasonable person would have been terrified.
Right.
I wasn't afraid of him. I wasn't afraid.
Or a witness saying they weren't afraid,
Right.
He didn't look scared to me.
Right. But the question of the intent, I think the actual belief is kind of analogous to, I'm going to tread carefully here, but reading people's mind is not something we can actually do. That's up to the jury it's a credibility determination. Typically, in a self-defense case, the defendant will take the stand and will explain how he was scared, and that's for the jury to decide.
But the reality is, overwhelmingly, these cases are going to be litigated on what we're not talking about, on the part that this case is about.
Right.
Whether there is an objective basis for
Correct.
the fear, and this other stuff, this hypothetical stuff. I mean, it's not that it could never come up, and that that we would not need to be careful about what we say and limit it to what we're actually focused on. But
the vast
there's
majority,
probably going to be a rare case where something other than what this element that we're talking about that's in this case is at issue.
The vast majority is going to be just the facts that we have here. Where an expert comes in to say it was reasonable to him because his perception of fear is elevated because he suffers from PTSD.
And in the ordinary course of things, if a reasonable person would be in fear, there's kind of a presumption that the defendant would have also been in fear.
Right. It's almost kind of a circular argument, right? If there are no further questions, the state would ask that you adopt the second DCA's opinion on the issue of PTSD in self-defense cases. Thank you.
Thank you.
There is a presumption of fear when something is objectively fearful, that you are actually also afraid, but you don't actually get the jury instruction unless you prove that affirmatively. And I would caution the court, we have a case now, Mizell, that stands for the proposition basically that we do this on a case-by-case basis. If you can articulate that your PTSD supports a legally cognizable version of self-defense, it can come in. And now we have Oquendo essentially saying, no, because by law, by statute, because of the way the jury instruction is written, this is diminished capacity. So I would caution the court to make any sort of narrow ruling, because I think the courts, and especially the DCAs and especially the trial courts, are very confused at this point about what is and what is not going to be allowed. So I would encourage you to be as thorough as possible so that that can be cleared up. Are there any other questions? I think the bottom line is that none of us are doctors. None of us are psych experts. The diversity of symptomology with PTSD is simply too complicated to be explained in these briefs and to be explained in this hour that I've been with you. So we should keep these matters being litigated at the trial court and keep admissibility on a case-by-case basis. As far as Mr. Oquendo goes specifically, we're asking for a new trial where he be allowed to present his state of mind evidence and where his jurors are not instructed by jury instructions that are constitutionally flawed. Thank you.
Thank you very much. We'll be in recess for 10 minutes.
All rise. All rise. The Florida Supreme Court is now in session. Please be seated.
Our next case is Allen versus State of Florida, 2023-1662.
May it please the court. I'm Elizabeth Spiaggi, and I represent the appellant in this case, Mr. Allen. And we're here on the summary denial of all of Mr. Allen's claims in his initial post-conviction motion under 3851. I do want to point out that presumptively, when there are factual determinations to be made, we are entitled to an evidentiary hearing. That's under Hochin. Additionally, there should be an evidentiary hearing on claims
But the reality is, aren't these all really claims of trial court error?
Well,
and this is, this is a situation where your client represented himself in both the guilt and penalty phases. He declined to present mitigation to the jury, and he kind of made his own case here. And now he's complaining about what folks didn't do and what the ineffective assistance of the trial court, ineffective assistance of standby counsel. And it just seems like all these. Why am I wrong in thinking that all of this is procedurally barred?
well, we are relying on all of those facts that were not presented. Those are what our claims are predicated on, facts that are outside of the record. So I don't see how those would have been raised on direct appeal, and these are things that were unknown to the trial court at the time of trial. So the court didn't.
But that's because of the choices your client made.
Well, I think that the first issue that I would address is that in post-conviction, we had an expert look back over the records, and she said she would not have found him competent to represent himself. And I do want to point out that in the examination that was done at the trial level, pre-trial, Dr. Meyer wrote that she defers to the court to determine his competency from a legal standpoint, given his intended defense or lack thereof. And the doctor also acknowledged that it was sort of an issue that Mr. Allen wanted to be sentenced to death, did not plan to challenge the evidence, or present any sort of mitigation. Now, one of the criteria for being competent is their ability to present a defense, or if it's competency to proceed, their ability to assist counsel in presenting a defense. And what the expert in post-conviction found is that there's a direct link between Mr. Allen's mental illness of PTSD and his inability to present mitigation. She touched on, in our expert's report, she touched on defensive avoidance, which is when someone tries to avoid situations which would cause them to re-experience their trauma, and intrusive experiences, which is when that happens and you're re-experiencing your trauma because of the situation that you're currently in. By not having an attorney and not having his family called to testify to mitigation, Mr. Allen was actively avoiding reconfronting this trauma that's very much linked to his PTSD.
Let's stipulate that all of that is true. Is your position that Mr. Allen doesn't have the right to waive that presentation?
I think given his mental illness, he it would have to be presented in some other form if he was sort of deemed, I don't know.
Do you take issue with the trial court's sustained, I want to say multi-year, but it may not be, multi-year colloquies, the Ferretta inquiry? I'm looking at December 20th, 2018, February 6th, 2019. There's an expert appointed to evaluate him in December 2018. Is all of that for naught? I mean, it seems like the trial court went to pretty considerable lengths.
And I would say that Mr. Allen was very clear on his intentions of wanting to represent himself, not wanting counsel, and that he wanted to be sentenced to death. But what I think is missing is the link between this idea that he wants to be sentenced to death and he wants to waive mitigation and the PTSD, which the court subsequently became aware of when the mitigation was presented. But the doctor at the pretrial level never made that link somehow between...
Is your argument that the Ferretta inquiry in this case was flawed?
No, I don't think that there's a problem with the Ferretta inquiry. I think that the main issue is that the court did not heed Dr. Meyer's advisement that she was going to defer to the court from a legal standpoint, that this guy isn't going to present a defense. That looks kind of like he's...
I'm sorry, and did the court lack discretion to do that? Was that an abuse of the court's discretion?
I think that the court doesn't have the knowledge of PTSD and the way it interacts with someone's decision making.
So is that a yes or a no? Is it an abuse of discretion or not?
I guess we'll say yes, it's an abuse of discretion because he should have relied more heavily on a psychological expert. Additionally, in post-conviction, that same expert opines that even Mr. Allen's desire to be sentenced to death is a result of his PTSD in attempting to control his situation and be somewhere where he's, not exposed to as many stressors as in general population. And again, that was really the missing link that the trial court did not have and that's now been developed. And so I guess the argument about it being procedurally barred is that there's this information that has been developed in post-conviction that shows that what the court did was prejudicial.
From your client's choices. And I understand you're saying he wasn't in a position to make the choices, but we got expert testimony to the contrary. And it just seems like there are two different ways to look at this. Your client's trying to exercise some agency here in a difficult circumstance, on essentially an indefensible case in terms of the guilt phase. Am I wrong?
Well, I would say that because of his self-representation, there were other serious omissions that should trouble this court. I mean, this was not an adversarial proceeding because Mr. Allen was helping himself to be.
But we have other proceedings that are not adversarial. For instance, when a defendant pleads guilty, okay, admits it. That's a legitimate thing. That's not, we don't say, oh, well, that's not adversarial. We're going to, even though he wants to plead guilty, we're going to go through some motions here to test whether, to create an adversarial process in the face of a guilty plea. I mean, so, again, he chose what he wanted here.
I just think this court should have a real problem with someone getting sentenced to death, perhaps just because they want to be sentenced to death, not because of the evidence that's presented. As I was saying, the other omissions are troubling. Mr. Allen actively supplied the state with aggravating evidence for the purpose of being sentenced to death. There's also the unaddressed issue of the prosecutor in this case being a mayor of a municipality in the jurisdiction, which those are facts extrinsic to the record, but the jurors did say that they knew the state attorney, and normally a defense attorney would have done some more questioning about that. How do you know him? What do you know him as? There's also the issue of the prior violent felony that was used as an aggravator. There could have been some very substantial cross-examination on that, because it's sort of what you're describing. It's doubtful.
You actually kind of get in the ballpark of arguing that it might actually, the prior murder might actually have been mitigating?
Well, yes. Because it's doubtful whether
I thought I caught that.
Yeah, so. It's doubtful whether he committed that crime.
So how? Explain to me how it would be mitigating.
Well, so that was a plea of convenience that seems to have been taken to shield his girlfriend from criminal repercussions due to her involvements in that. And so I think that the fact that he may or may not be guilty of that.
Is there any case where we've said that circumstances surrounding a prior murder conviction are mitigating?
Well, I think that the jury could look at it as a chivalrous act, that he doesn't want his girlfriend who's pregnant with their child to be incarcerated, and that instead he's taking the rap for her. I think that some jurors could see that as a mitigating circumstance of the defendant's background. Additionally, it kind of diminishes the weight of that aggravator if the jury had been led to question whether he actually committed that or whether it was just a plea of convenience. And all of that investigation into the prior was done in post-conviction and was unknown to the jury and unknown to the trial court. Additionally, I think the elephant in the room, the court forbidding everyone to contact Mr. Allen's family. So historically, this court has concerns about defendants.
Well, now that was at the request of Mr. Allen, correct?
Again, as I think we have established, because you have to accept the facts from post-conviction as true since they were summarily denied, that was, again, a result of him not wanting to confront his family testifying about this past sexual trauma of his childhood. And once Mr. Allen sort of indicated that he was going to limit the amount of mitigation. So historically, this court has issues with that, and Muhammad gives some guidance as to what trial courts can do, and the court followed that guidance in appointing special counsel and a mitigation investigator and ordering a comprehensive PSI. But then the court sort of circumvented the whole purpose of Muhammad in forbidding all of these people to contact the defendant's family, which would have been the source for all this mitigation that the court, it seemed, did want to hear in spite of Mr. Allen's wishes. And I think that's the whole point of having special counsel, is so that the court can be informed of mitigation that the defendant may or may not want presented.
Have we ever reversed because of a Muhammad error? Because the trial court did not do something under Muhammad?
I think that I don't believe you have. I would have to research that, and I could submit supplemental briefing. But I think the point here is that the court, it would have been one thing if the court was like, I'm not concerned about his lack of mitigation, but here the court had concerns, and that was the reason for him, appointing special counsel. So it really...
Well, it seems to me, if you look at what happened here, the court is trying to chart a careful course where the court gets access to mitigation, but the court also shows respect to your client and does not just say, well, you don't want us to talk to them, but we're going to talk to them anyway. And it seems like to me he's trying to be respectful of the autonomy of your client while getting as much information as he can while respecting that autonomy. So I don't think the idea of denigrating the trial court for taking that approach seems to me to be misplaced.
I understand that the trial court was put in a very difficult position here, but it still stands that an individualized sentencing requires that the trial court hear mitigation in order to properly assess what the sentence should be. That they have to have some understanding of what mitigation is out there. I would point to this court's decision in Robinson, where you held that the trial court has a responsibility to weigh, to consider all available mitigation and weigh it. And I would point to Justice Pariente's dissent in Spar, which we cited in our brief, just to kind of address the procedural bar argument again, that when it's not necessarily always error for the court to for the court to say that counsel can't contact the family, but in this case it was prejudicial because the family had a wealth of mitigation that they would have come and testified to. And all we're asking here is for an evidentiary hearing so that the trial court can hear that and at that point can make factual determinations and assessments. There were also other outside factors besides the court's prohibition. There was the lack of JAC funding for due process providers, which special counsel cited in saying to present an effective penalty phase, you would really want all of these different experts, but we're unable to retain those currently. The abbreviated time frame, I think, also contributed.
Did anybody ask for a continuance to deal with that?
I believe. I
mean, there was a continuance given, but subsequently, did anyone say we need more time to work on getting what we need to get here? Wasn't the real problem the limitation that your client had placed on contacting people?
I think there are still other people that the experts, of course, could have been contacted. That wasn't part of what the court forbid. Additionally, I think the mitigation specialist testified that she normally would get school records, and she would have to go to Michigan to do that, and that was not done. But we did do that in post-conviction, and I did have to go to Michigan to retrieve those. And just giving time in addition to the lack of funding. I also don't know, given that they were special counsel, I don't know that they felt that they had to present an effective penalty phase, right? So there were things that would be done and were done in post-conviction, and I think the prejudice is that, sorry, let me go back to the records that were collected. The school records came from both the public school and the boys' home that Mr. Allen was at. They showed an IEP, which is sort of important. Additionally, those records indicate teachers and counselors who could provide additional background information about Mr. Allen, which also would have been within the court's sort of forbidding. He forbid them from talking to family, but they still could have contacted other sort of periphery folks who might have had a lot of information, like these that were indicated in the school records. As far as the experts, in post-conviction, we retained both a trauma expert and a drug abuse expert who opined about Mr. Allen's drug abuse and its effects on his brain. And I think that those are things that were sorely missed from the Spencer hearing and from what the trial court heard.
You can see that constitutionally the only thing that someone is entitled to in terms of mitigation from a process perspective is that there be full and fair consideration of whatever they affirmatively want to put forward.
No, I would not concede that. I think that an individualized sentencing takes into account individual characteristics of the defendant, whether the defendant is willing to present them or not.
So what's your authority for that?
Well,
because it seems like all these arguments are basically just kind of, we came up with this kind of good government kind of thing in Muhammad, and now we're arguing about how to implement that, but really there's no there in the sense of an actual constitutional entitlement to it.
I mean, it's implicit under due process that you have an individualized sentencing that considers the specific background of the defendant.
Okay. You're down to your last minute. You're welcome to keep going.
I will save that.
Okay, thank you.
Good morning, Your Honors. May it please the Court, Jonathan Tannen, representing the state of Florida with respect to the appeal of the denial of post-conviction relief and the Secretary of the Department of Corrections with respect to the habeas petition. The post-conviction court in this case correctly denied Mr. Allen's motion for post-conviction relief based on its determination that each of the issues that he raised in the motion was procedurally barred. Rule 3851 states this rule does not authorize relief based upon claims that could have or should have been raised at trial and, if properly preserved, on direct appeal of the judgment and sentence. In this case, as Justice Kennedy stated, each of the claims that was raised in the were raised in the motion was an issue of trial court error. Each issue had something to do with an error or omission by the trial court during the Spencer hearing with respect to issues 1 through 12 of Mr. Allen's motion. And issue 13 involved comments that were made by the prosecutor during jury selection. And then additionally, claim 14 was a claim of cumulative error. All of those issues were matters that could have been raised before the trial courts during the trial proceedings and could thereafter have been raised on direct appeal to this court. The appellant did not do that, and on that basis, the post-conviction court correctly determined that his claims were procedurally barred, and it therefore denied post-conviction relief in full. As to the merits of the claims, Mr. Allen's counsel has discussed the claims 8 and 9, I believe issues 8 and 9 rather, in the initial brief regarding Mr. Allen's competency for self-representation. Under Indiana v. Edwards, the standard for competency for self-representation is severe mental illness, and the record makes clear that there was no severe mental illness in this case. In order to constitute severe mental illness, it has to be the case that the defendant is unable to carry out the basic tasks needed for his own defense, including, as the Supreme Court has stated, the organization of defense, making motions, arguing points of law, participating in voir dire, questioning witnesses, and addressing the court and the jury. In this case, Mr. Allen was initially evaluated by Dr. Meyer prior to the second Ferretta hearing and prior to the trial court granting his request for self-representation. He had no issues in speaking with Dr. Meyer. She found no concerns as far as his understanding the proceedings, his ability to communicate with her. He explained in very great detail, as she documented in her report, his reasons for seeking to represent himself and to waive mitigation. He also had no problem communicating with the trial court during the trial proceedings. And during the trial, he ultimately represented himself. He filed pro se documents. He examined prospective jurors. He exercised 4 cause challenges and peremptory strikes. He gave an opening statement. He cross-examined witnesses. And he repeatedly discussed legal issues with the court throughout the proceedings. So even if he had challenged this issue, there would not have been a basis for the trial court to deny Mr. Allen's request for self-representation under these circumstances, since he clearly did not suffer from severe mental illness within the meaning of Indiana versus Edwards. As to issue 11, I believe that was raised briefly, the prosecutor's comments during jury selection. The fact that the prosecutor was apparently a former mayor of the town had really no relevance to the proceedings, and in any event, the prosecutor's comments were not a misstatement of law, as the record shows. He questioned the prospective jurors on whether they would be able to, whether they believed they would be able to impose the death penalty if they determined the circumstances were appropriate, which is the correct legal standard. He did not tell the jurors that if they determined that the aggravators outweighed the mitigators, then they would be required to impose the death penalty. And since the comments were not improper, there would not have been any basis for relief on direct appeal, even if this issue had been raised or challenged in the lower court. As far as the order that Mr. Allen's family not be contacted, this court has repeatedly stated that the defendant has the right to control the objectives and content of his mitigation, and it has specifically approved prior instructions by a defendant that his family not be contacted. And in any event, it did not violate his right to an individualized sentencing because, as the Supreme Court has stated, the right to an individualized sentencing under the U.S. Supreme Court's precedents is the right of the defendant to present sentencers with information relevant to the sentencing decision and oblige sentencers to consider that information in determining the appropriate sentence. And in Kansas v. Marsh, the Supreme Court said the thrust of our mitigation jurisprudence ends there. So Mr. Allen intentionally waived mitigation. He chose not to present it. He chose to not allow the court to contact his family or to allow special counsel to contact his family, and he had the right to make that decision under these circumstances. With respect to the JAC funding lapse, the special counsel explicitly said in his filing that he was not reliant on JAC funding and that he was merely keeping the trial court apprised of the matter. The reason experts weren't hired and retained is because Mr. Allen had said that he would not meet with any medical experts. He agreed to meet with special counsel's psychiatric expert, Dr. Falb, and he did speak with Dr. Falb, who testified at the Spencer hearing, but he made very clear that he would not meet with any other experts. And finally, as far as the question of the continuance, the trial court granted the only continuance that was requested prior to the Spencer hearing, and Mr. Allen had explicitly objected to even that request. Does the court have any questions about any of these issues? Hearing no response, I will again rely on the state's briefing for any further points. Thank you.
Thank you very much.
Just to touch briefly on some of the issues raised by the state. As far as the continuance and the willingness to meet with experts, Mr. Allen willingly met with Dr. Pritchard and Dr. Falb, and the trial court noted by the end of the Spencer hearing that it appeared Mr. Allen had had a change of heart in relation to his mitigation. It's clear that Mr. Allen, had more experts been brought forward, would have met with them due to this change of heart about the mitigation. Additionally, at the end of the Spencer hearing, Mr. Allen did ask for more time and assistance in composing, or the assistance of special counsel. The state cites to Marsh, which explicitly states that a sentencer cannot be precluded from hearing mitigation. And I guess our argument is that essentially that is what the trial court did. They imposed this impediment to hamper the mitigation that they heard. Additionally, as far as Ferretta and Mr. Allen's competency, Ferretta, this quote I believe comes straight from the state's answer, to thrust counsel upon the accused against his considered wish violates the Sixth Amendment. This is contemplating someone who is making a considered wish, who's weighing pros and cons. That's not Mr. Allen. Mr. Allen was compelled to represent himself in order to avoid confronting painful mitigation. I would ask this court to reverse and send it back for an evidentiary hearing where these facts can be further developed and factual determinations can be made by the trial court. And I would urge this court to look at this on a case-specific basis. Some of these court errors They might not always be errors, but in this case, they appear to have been prejudicial, and we would like the opportunity to develop that further at an evidentiary
Okay,
hearing.
thank you very much. We appreciate it. Our last case today is Damas versus State and versus Secretary, Department of Corrections, numbers 2023-1476 and 2024-0565.
Good morning. May it please the court, James Driscoll on behalf of Misak Damas. Mr. Damas should have never been pushed through the court system, and as a result, his death sentence is unreliable. He was denied the fundamental protections of the Constitution. He was not competent to proceed during his trial, court proceedings, and he was not competent during post-conviction. And when he was run through the system, he went through without the protection of the counsel that the Sixth Amendment guarantees. Counsel should have acted as his advocate and contested his competency. If Mr. Damas was going to be forced through the courts, his counsel should have timely developed and presented his mitigation. After counsel failed him, the Constitution gave him the right to the effective assistance of appellate counsel, and that counsel failed him as well. Mr. Damas had a number of competency proceedings, and in 2014 he was found incompetent and he was sent off to GEO care for so-called treatment. And so he was there for about 20 days, at which point they ran him out of the treatment center and sent him back to the courts. At that point, rather than contest the findings of the doctors that were reappointed to evaluate him, his counsel merely not only stipulated to considering the reports, one of which was by Dr. Mandelblatt, which was a scurrilous report, which was basically a character attack on Mr. Damas. They also stipulated to competency
if we
itself.
leave aside the Mandelblatt report finding him competent, don't we also have the Herkov, Scharf, and McMurray, and Kling, and Harper reports? Well, he was incompetent.
He was found competent earlier.
So no, those are. I'm sorry. The last Harper report is August 26th of 22, and there's another one on August 30th.
That was for post-conviction.
Right.
Okay.
So I mean, you're doing a great job arguing for your client, but I think it would be disingenuous to ignore, by my count, 8 different reports, maybe 9, finding him competent to proceed?
Well, he was found competent to proceed, but he was found competent by Dr. Herkov and Dr. Scharf, who earlier, right before that, said he was both mentally ill and incompetent. Then all of a sudden he gets placed.
But so the fact that they had earlier found him to be incompetent, it seems to me actually strengthens their subsequent determination that the treatment had restored his competency. I mean, that's why he was sent to the treatment facility to restore his competency, and they determined that whatever had been done there had been effective in restoring his competency. So the fact that they had previously said he was incompetent, rather than undermining their subsequent determination of competency, actually strengthened it. They were willing to determine him to be incompetent, but that's a competency has to be determined at a particular time. But after, am I wrong in thinking that after February of 2014, when there was a determination of incompetency, that there were just one determination of competency after another? 2014, 2017, 2020. and then up through till 22.
Well, there was competency in post-conviction because
Right.
counsel moved and actually did a hearing on that. And that's what counsel never did for Mr. Damas when within 20 days he's miraculously cured. And if you look at the reports of Dr. Scharf and you look at the report of Dr. Herkoff, who had said I think Dr. Scharf said he had bipolar disorder, and Dr. Herkoff said he was on the schizophrenic spectrum. Then all of a sudden, after this scurrilous report by Dr. Mandelblatt.
You keep calling it scurrilous, but the report found that your client was malingering, and there was 5 weeks of clinical observation that went into that report. Why do you call it scurrilous?
Well, it was a personal attack on Mr. Damas. If you read the whole report, that should not be an
personal
expert
attack. Obviously, it's personal because it is personal to Mr. Damas's mental state. But how is it an attack?
It's an attack on his character. If you look at that, if I put that in a brief, I would be accused of making an ad hominem attack, and that's exactly what Dr. Mandelblatt did in this case.
But the reality is, if he determines that he's malingering, that is an attack on his character. I mean, that is, and there's just no way around it.
Well,
but we know, I mean, that people do malinger. They aren't always malingering, but people do malinger, and it's an established category of evaluation in these sorts of examinations. And so the bottom line is, after they washed him and they saw what was going on, they determined he was a malingerer.
Well, I don't think Dr. Mandelblatt spent 24 hours a day with him. This is reports, and that was never part of a hearing. That could have been contested if counsel had just acted effectively. But what Dr. Mandelblatt, what she did was created a narrative, and a false one, that Mr. Damas was volitionally obstructing the court system. And then I believe my colleague's going to get, opposing counsel is going to get up and argue that this was some sort of gamemanship. But what game is Mr. Damas playing other than trying to get himself killed? And it could have been, and there were opportunities we're talking about 2014 where he was found incompetent, then found competent again. Time goes by and those reports become stale. And so what happened in 2017, it wasn't counsel that moved for him to be evaluated for competency. It was the judge, the same judge that eventually found him competent, who ordered the competency, was conducting his own investigation on whether Mr. Damas played chess and things of the like. So there was never a proper hearing where counsel contested the idea that this was malingering, that this was volitional. And in fact, in 2014, counsel stipulated the competency, which that's not supposed to happen.
Let's say we agree with you that more could have been done, just hypothetically, to explore the claim of malingering. Am I correct that at the end of the day, the trial court's denial of relief here is a matter of abuse of discretion?
Yes, Your Honor,
okay,
and it's contrary to the facts.
Working with that, you'd have to show that no reasonable judge could have considered the more than half a dozen consistent competency findings and then have determined, okay, I'm going to find this person competent.
No, that would be for the this is a Strickland claim. So we're looking at the performance of counsel, and counsel was deficient by stipulating the competency.
Because it wasn't raised on direct appeal, because it was waived on direct appeal.
Well, they didn't. There wasn't a whole lot raised on direct appeal, which I can get to.
I mean, that gets to another problem about what's foreclosed here. But
okay,
I digress.
But Mr. Damas needed a hearing where counsel could have cross-examined Dr. Mandelblatt, where counsel could have put on, as I cited, a competent expert like Dr. Agarwar, who could explain why it's not just him being obstructive, how his perhaps sincerely held religious beliefs interact with the schizophrenia spectrum. And that was never heard, and that was never done. And in the end, nobody could help Mr. Damas because he was so mentally ill. He couldn't interact with his counsel. At times he would, and at times he wouldn't, which is consistent with his mental illness. The fact Dr. Mandelblatt citing things like he went and got banking when he was at the center. Well, it's not like it's 24/7, he's acting out. It's when certain periods come, it gets very acute. He cycles in and out of this psychosis. And at the end of the day, the state of Florida, the judge sentenced an incompetent man to death, and it did so without properly considering his mitigation, and that brings up the other claims where Mr. Damas could have shown that, in fact, he wasn't malingering, he had a mental illness. It became a whole thing in that sentencing order that the sentencing judge discounts his mental illness when, in fact, he's schizophrenic, and that was found by Dr. Aguilar, and that was also found by Dr. Herkov at one point on the schizophrenic spectrum. So we have that, and then multiple doctors asked these attorneys, please get us these very precise scans and we could see the schizophrenia. And that wouldn't necessarily rely on Mr. Damas, and those pictures would have been able to pinpoint and show that, in fact, he does suffer from a mental illness. It's not just volitional. It's not a personality disorder. He's severely mentally ill in addition to being brain damaged. But the court doesn't allow the scans to be done and doesn't fund Dr. Wu to come in and to do that. So instead, they go to a Spencer hearing, at which point they put on Dr. Rubino, who's a neurologist, who has no business testifying that Mr. Damas has schizophrenia. He could only look and say there's parts of his brain that was consistent. And that doctor, too, Dr. Rubino, still wanted those additional scans because it would have been a more precise picture. And it would have been something that the sentencing court could not have discounted and denied Mr. Damas a fair penalty phase. His death sentence is beyond the Eighth Amendment. Because of Mr. Damas's incompetency, none of the rights could protect him. It's unreliable, his sentencing, and at the end of the day, it should be reversed. Moving on to, in addition to that, if Mr. Damas is not severely mentally ill and he's just annoying, well, he should have been allowed to represent himself. And I've presented to the court, which was omitted on appeal, that Mr. Damas had moved twice to represent himself, if not more times. But the one that was omitted by appellate counsel in 2011, Mr. Damas stands up and says, I would like to represent myself, at which point the court says, that's fine, Mr. Damas, but we're going to have to wait for another doctor. You come back and we'll do the Feretta inquiry then, basically. At which point, the same exact day, the judge issues an order denying him self-representation. If Mr. Damas is not severely mentally ill, as we submit, and which is the absolute truth, then he should have been allowed to represent himself. And so there was no Indiana v. Edwards if he doesn't have a mental illness, a severe mental illness. And in fact, in 2011, he was told he would be heard and that he could ask for his self-representation. And the very, very same day after the judge had told him, we will come back and consider your self-representation, Mr. Damas, the very same day that judge denied it. And that's a violation of Mr. Damas's constitutional rights. Additionally, in the habeas, I also argue about the report of Dr. Mandelblatt, which has no business being considered, especially considering Mr. Damas waived mitigation. But I was very upfront with the court that counsel asked the court to consider to look at that to see whether whether he received any treatment while he was at the center for that limited purpose. And that Mr. Damas, if he's competent, counsel should not make that decision to waive his privacy right and deny him what's guaranteed by both the Florida and the United States Constitution. He had a right to have that held confidential, and then he never waives it. There's no record. There's nothing on the record. Counsel just goes forward probably against his wishes. Nobody really knows what Mr. Damas's wishes are. Goes forward, alerts the court to Dr. Mandelblatt for a very specific purpose, at which point the sentencing court came back in and used Dr. Mandelblatt to overwhelmingly justify a death sentence. It became non-statutory aggravator. The state itself could not have written a worse report than what Dr. Mandelblatt wrote about Mr. Damas. And so in addition to that, we have we have the, I believe I alluded to it earlier, we have Mr. Damas had, he had, like counsel, on September 1st, 5 days before the trial is going to begin, counsel finally moves for the additional scans and to have Dr. Wu travel to come testify. And at which point, which is like, if you look at the record, there was never any doubt that Mr. Damas was going to plea. He had wanted to plea from the very beginning. But so that would mean that if you don't waive penalty phase, you're going forward with a penalty phase in front of a jury. And counsel was still asking for scans 5 days before the jury was would have been selected. And so he doesn't even have that, and it's particularly egregious when you consider how the sentencing court discounted his mitigation and how they used that to what you call to justify a death sentence. Overwhelmingly, counsel did at the Spencer hearing present some evidence, but then whatever they were presented was eventually turned around against Mr. Damas, and that was particularly unfair, especially since he never consented to Dr. Mandelblatt's report, and especially considering he was denied the very precise scans that he needed to show that he had schizophrenia. And that's in addition to counsel not developing any other experts. They had a whole period of time. They had the whole period
Dr. Rubino does get both an MRI and a PET scan, though, doesn't he?
He gets he gets the basic version, but there's been developments in the PET scan that very precisely can show things like schizophrenia, things like his brain damage. It's like the difference, I guess.
Which case of ours holds that someone is entitled to a particular type of PET scan and MRI scan?
Well, it's not necessarily your cases, but it's AIC, and he has the right to develop his mitigation and present it. And the fact that, and what you call it, the law moves along with technology, and if that PET scan and that MRI, I think it was the MRI which was more precise, if that would have showed that Mr. Damas was schizophrenic and further show his brain damage, and it could do so more accurately.
When you refer to brain damage, are you talking about the car accident?
Well, no, he probably had brain damage his whole life. There's all sorts of things, but that never could be pinpointed because they didn't have the right experts to work with him. I mean, by the time they got around to bringing Dr. Woe with an O into the case, by that time he had decompensated so far he wouldn't meet with Dr. Woe, but sometimes he would meet with an expert. He met with the very able Dr. McAllister, who provided very important mitigation in this case and showed the background of Mr. Damas, but that was a professor of African American studies, not a psychologist, not a psychiatrist, not a neuropsychologist. And Mr. Damas needed to have that in order to properly determine whether he is in the class of individuals who may be subject to death. It's a critical Eighth Amendment principle that we're saying is that after Furman, in order to impose death, we have to narrow the class of individuals who are subject to death. And indeed, Mr. Damas had a lot of aggravation, I will concede that, but there was a lot of mitigation that should have been presented so that when the judge determined whether he should live or die, the judge knew all the truth and knew all the facts. But he couldn't develop that because he wasn't given funding for those additional tests. And of course, that was due to counsel being ineffective, additionally, by not having him evaluated earlier on in the process. I don't know how they were going to get him. If Mr. Damas didn't come in on the 5th and plead and say, I plead guilty and waive a penalty phase with a jury, if Mr. Damas came in and said nothing, they were going to a jury trial. That's how close to the line this defense counsel did, and that was ineffective. So when was Mr. Damas going to get his PET scan and MRI if, in fact, he's sitting there in the courtroom the whole time? When was this supposed to take place? I've done PET scans and MRIs. I don't think they have night hours. That was because counsel was deficient, didn't bother to prepare, and waited much too long. They didn't get active in this case until after the Hearst stay.
Counsel, you're welcome to keep going, but you're down to a minute of your rebuttal time.
Okay, I'll save it.
Thank you.
May it please the court, Timothy Freeland on behalf of the state of Florida. I note that the calendar indicates that Mr. Tannen is supposed to be arguing this, but I am. Let's start with issue one and the question of competency. First, I want to address the issue that whether it was proper for trial counsel to stipulate to the defendant's competency. The state's perspective on that, our view is that it's irrelevant. Trial counsel cannot stipulate to the competency of the client. The role of the attorney is to be advisory, to set things in motion, to tell the judge, we have a good faith belief that the client is not competent, whereupon the experts come in and make an evaluation, and the court makes a determination based upon those experts. On October 8th, he was returned from Treasure Coast, the long-term treatment facility. Dr. Mandelblatt's report at that point, plus the other two experts, all concluded that he was competent. And I have the order, which is attached to the trial court's order denying post-conviction relief. And it states, a hearing was scheduled for October 8th, at which time the parties stipulated to the defendant's competency. It does say that. But I think that was for the purposes of memorializing what had happened on that day. If you continue to read the balance of that order, the fact that the parties had stipulated competency is not mentioned ever again. And instead, the court...
What it means is they just didn't object to the determination of competency.
Correct. That the court could rely upon the reports in order to assess, which is what the court would have to do in any event. So the defendant was initially found to lack competency in March of 2014. He was sent to the GeoCare/Treasure Coast long-term treatment facility, and when he returned, he was deemed competent on October 8th. And as the court noted, every competency evaluation ever since then has found him to be competent. Opposing counsel just refuses to accept the fact that since he was returned from Treasure Coast, every expert to examine him found him to be competent. If we turn to the second issue, mitigation, the vast majority of mitigation that counsel obtained in this case was over the defendant's objection. The defendant made it quite clear that he did not want any mitigation to be presented, and he actively obstructed counsel's efforts to try to gather that mitigation. And in spite of those obstructions, counsel did a remarkably good job of gathering mitigation. They hired a mitigation expert whose name was Murray. They hired a cultural expert, Dr. McAllister, and the two of them actually traveled to Haiti under difficult circumstances. Haiti has for a long time been on the do not travel list of the State Department. And at that time, they had just had a major earthquake. So they went, Dr. McAllister was able to locate members of the family and spoke to them, I think an uncle. She also went to his school and got information about his family from the principal of the school who remembered him. This is not a case where counsel sat on their hands and did nothing to evaluate or to assess the mitigation, the available mitigation. Was there more mitigation available? Yeah. But the defendant refused to cooperate, and the state hired two experts to do the additional testing, but the defendant refused to meet with those experts. So what is an attorney supposed to do under those circumstances? Well, they do the best they can. Counsel came up with a list of 42, and then they culled it down to a list of 30 some odd mitigators that they would have presented had the client cooperated. Turning to the question of the Ferretta hearing, there were 2 Ferretta hearings, and appellate counsel sought to have this court review the first, the one in 2017, and elected not to challenge the one that was in 2011. The one in 2017 was the stronger of the 2, and that's one of the things that appellate counsel is supposed to do, is to winnow out the weaker arguments. And the fact that Dr. Mandelblatt's report was introduced was clearly done with the waiver of counsel. Counsel invited the court to examine it. I don't have any other argument. If the court has any questions, I'm open, but otherwise that concludes. Thank you.
Thank you.
Just briefly, Mr. Damas didn't need an advisor for the court. Mr. Damas needed an advocate. That's what the Sixth Amendment guarantees, and they're supposed to contest these things. They're supposed to act on his behalf and challenge things. Just because an expert says something, that is not the end of competency. It is a legal decision, and a legal decision based on opinions, but each opinion can be challenged. And they could have hired their own expert and brought Dr. Agarkar, which I mentioned, or some other expert who was not so against Mr. Damas. And the other thing is I must take issue with the fact that there was any sort of winnowing in this. You get 25,000 words on a direct appeal. I have the exact number in my brief, but I believe that Mr. Damas only got about 4,000.
What winnowing are you talking about? I'm sorry.
The opposing counsel mentioned that, like, appellate counsel limits the issues. Well, the appellate counsel had perhaps 21,000 more words which to use, and to add another Ferretta.
In terms of the brief limits?
Yes. Yeah, so there was plenty of room.
I'm not sure that we judge briefs by how long they are. Maybe we judge them in reverse sometimes.
Well, we don't, but we do judge them on whether they meet the requirements of Strickland. And in this case, it certainly did not. When Mr. Damas moved for competency, was promised that, and then he ultimately was denied. And I see I'm almost out of my time, so unless there's any more questions, I will ask the court to rely on the briefs and ask you to get Mr. Damas relief.
Thank you very much. We're adjourned for today.
All right.